On behalf of Brickcourt Chambers, I'm very pleased to welcome you to this conference on commercial fraud, law and practice. Litigation concerning commercial fraud has, in recent years, undoubtedly become one of the mainstays of modern commercial practice. We hope in the course of the afternoon to be able to provide some insights on winning strategies and recent legal developments in this ever-growing field. By way of introduction, I thought that I would mention some further problems that frequently arise, not so much as to provide answers, but to provide some further food for thought. Much, if not most, of the commercial fraud, the subject of litigation in this country, has an international element. That creates particular challenges. The first is jurisdiction. On what basis does an English court assert jurisdiction? Indeed, the dispute often has no connection with this country, being concerned with events in the far-flung regions of the former Soviet Union or the Middle East or Far East or Africa. So how does it come to be litigated here? Well, very often the connection is provided by the presence of a defendant in this country. But plainly the first challenge in such cases, if you're acting for the claimant, is to establish jurisdiction, and if for the defendant, to undermine the connection. An interesting example of the jurisdiction battle is provided by the VTB case, which went up to the Supreme Court a few years ago, and where there was a 3-2 split between the justices as to whether VTB, a state-owned Russian bank, should be entitled to sue the aptly named Mr. Malofeev for an alleged fraud which, per Lord Mance, was hatched in Russia, but which involved extraction of funds from an English bank account. The differing approaches of the justices provide an insight into the difficulties of deciding how far the jurisdiction of the English court extends. Even if jurisdiction can be established, further problems are thrown up by conflict issues. Whose law applies? For instance, Sickle and Samba was another recent decision of the Supreme Court concerning alleged misappropriation in Saudi Arabia of shares in Saudi banks supposedly held on trust for the claimant, a Cayman Island company. The difficulty was that Saudi Arabia does not recognize trusts. The defendant, a Saudi bank, claimed to have received good title to the shares under Saudi law. Could the defendant recipient of the shares be held liable according to English principles of constructive trust? How far does equities writ run? Is it sufficient that the English court might regard conduct wherever committed as unconscionable to render a defendant liable? Whilst the Supreme Court held that a trust could exist over shares in a state that did not recognize the concept of a trust, the further questions concerning the extent of equities reach are still being explored in the ongoing litigation. Even if English law does apply, to what account is it appropriate to take account of standards of commercial conduct in the foreign jurisdiction, and how do you establish such standards? It's the frequent refrain of clients from exotic jurisdictions that what they did was perfectly normal by the standards of that jurisdiction, and they should not be judged by Western standards. That is a thorny and difficult issue. As I said at the outset, rather than providing ready answers, I would leave you to ponder on these points as food for thought. Before I introduce our first speaker, I wish to say how delighted we are that Lord Neuberger has agreed to join us today. As you all know, Lord Neuberger recently retired from being President of the Supreme Court after a distinguished legal and judicial career. He was called to the bar in 1974 and took silk after only 13 years in 1987. He was appointed to the High Court in 1996 and elevated to the Court of Appeal in 2004. In 2007, he was appointed a Lord of Appeal. His rise to the Court of Appeal and to the House of Lords was one of the quickest in modern times, and indeed truly meteoric. As if being the youngest sitting judge in the House of Lords was not enough, he then became Master of the Rolls in 2009, a post he held until 2012, when he succeeded Lord Phillips as President of the Supreme Court. So we're incredibly fortunate and most grateful that he's agreed to join us this afternoon, and we're indeed honoured by his presence. Now, before introducing the first speaker, I'd like to say something about the format. We will hear from each of our speakers in turn. We will then have an opportunity for questions and a round-table discussion led by Lord Neuberger. And so on to our first speaker. Michael Swainston QC will address us on the importance of forensic analysis.
Ladies and gentlemen, Lord Neuberger, colleagues, it's a great pleasure to begin our session today by talking about evidence, because evidence is a very good place to start. Indeed, below the rarefied climes of the Supreme Court, most cases do turn on the evidence and what happened in fact, especially in the context of fraud. But where to start in proving fraud and deciding where to look for forensic issues? Well, sometimes the target of inquiry is pretty clear. Here we've got a painting. It was a fake painting, as things turned out. It was one of many fakes that brought down the Neuberger Gallery in New York. And it was supposed to be a Jackson Pollock, and if real, it might have sold for $140 million. So it's easy to see the temptation to get one's 5-year-old to forge one. Unfortunately, these days, that is quite difficult. If you use modern paints to make an old painting, that shows up when somebody examines the pigments with a Raman microscope, which blasts off a few molecules and spectroanalyzes them. If you mix your own paints using original minerals and the recipe of the old masters and oils, that won't work either, because any natural oils after 1945 will have traces of cesium-137 and strontium-90 from nuclear bombs in the atmosphere, and that's a dead giveaway, according to the Russian Museum in St. Petersburg. And then there are always the prosaic mistakes. Leaving a nylon fiber in the paint on an old master is a bit of a giveaway, and not teaching your 5-year-old to spell Pollock is another problem. But on any view, paintings are perhaps a special case, and not one that one comes across very much. What about fraud in general? How do we tell when people are telling lies? Well, generally, it's not good enough to leave everything to trial and cross-examination. For one thing, you won't get there unless you can properly plead a fraud case, which means collecting some evidence first. And when you do get there, it seems that you can't necessarily trust the judges to spot a liar. Aldert Vrij is a professor of applied psychology at the University of Portsmouth, and he's written a very good book about all aspects of deception. He covers the best methods of interrogation, the nervous tells that give people away, and so on. But he then explains rather disarmingly that all of his techniques have limited value. It turns out that professional liars are very good, and professional lie catchers, like policemen and judges, often don't do very well at spotting them. Indeed, Vrij cites laboratory tests where professional lie catchers were only 56% accurate, appraising truthfulness on the basis of verbal and non-verbal behavior. And lay people actually did better at 63% as opposed to the judges' 56%. Of course, there were some judges who did better than the average at spotting liars, but that turned out to be because they thought everyone was lying. So Vrij ultimately agrees with Lord Gough in The Ocean Frost that the best basis of assessment of whether people are telling the truth in the witness box is comparison of what the witness says with objective context and objective facts which are independent of their testimony. And in a fraud case, that often comes down to forensic evidence. Now, most people here will have worked with handwriting experts and forensic accountants, and I don't want to tell you stuff that you know. The idea is to alert you to some clues and techniques that may not be so familiar. The first point, though, is a rule of thumb. The risk of falsehood is proportionate to what's at stake, and what to look for depends on what's in issue. Now, an obvious and regular example in commercial litigation is a forged document where it's suspected that a signature has been transposed. And often only a copy of the document is available, which can be suspicious in itself, but there are often reasons for that. If there is only a copy, your forensic experts will tell you there's a problem because they have to have the original to form any decisive view. But there may still be important clues. First, it turns out that all photocopiers have faults. So on every page of every copy, there are trash marks. And if a page has been copied twice, if you look very closely with a magnifying glass, 2 lots of trash marks will give that away. Another clue is relative fuzziness under a microscope. Every time a copy is taken, because of random data noise, the lines become fuzzier. So if a signature is fuzzier than the rest of the page, that suggests a different history. And also, different copiers spit ink in different directions, so that if on vertical lines, some have dots on one side of the line and the text has dots on the other, that again indicates different histories. Ed Harrison in Chambers and I had a case that turned on this kind of thing. We managed to prove that the contracts in issue were false and created after the event, and we even went on to show that the author was a lawyer on the other side. Some more points. There can be issues on dating of inks. You can tell when a signature was put on according to how dry the ink is. Biros are best to conceal that because they dry the slowest. And another giveaway is where the signature doesn't match sample signatures from the date when the individual is supposed to have signed. If you dig out your own old passports and look at the signature, you'll see quite pronounced changes over time. And if you chart those, it's possible to check whether a particular signature is real or not. But what about new developments in forensic science? Well, you may have seen recently that an American lady called Reality Lee Winner, inapposite as we'll see, was in trouble recently for leaking a report on alleged Russian interference with the American election. And the report seemed to indicate an absence of evidence to that effect. And unsurprisingly, the NSA wasn't very happy about the leak. Reality Winner was arrested within about an hour of the document being released online. And it now looks as though she may have been identified as a result of a long-standing deal between the security services and copier manufacturers. It turns out that when you make a copy using pretty much any color photocopier, it prints yellow dots on the page that you can only see with a magnifying glass and under blue light. But the pattern of the dots says what machine did the copying and the date. Now that the secret is out, one can see that as a technique for spotting fake copy documents. But what if the physical attributes of the document give nothing away? Can we get anything useful just from the content? Well, yes. The first thing is authorship. We all have personal usages that give us away. So if a judge uses classical allusion, that narrows it down a bit. If he talks about an idea bursting forth fully formed like Pallas Athene from the head of Zeus, we would know that the judge was Christopher Clark. Less obviously, this kind of technique was used recently by the Russian government in the appeals from the UKOS arbitration decisions. They used expert analysis from Dr. Karol Czasky to show that the secretary to the tribunal had written most of the award. And those cases have proceeded on other grounds so far, but that continues to lurk as one ground of appeal. But what about the content of financial documents? Can we tell from the document alone whether numbers have simply been made up? Well, the answer is sometimes yes. And not just because at the top of the page it says benefits of Brexit. One might think, writing numbers off the top of one's head, that the odds of a particular numeral cropping up at any point would be 10 to 1, 0 to 9, and any digit could be any number. That turns out to be wrong, because in the decimal system, it takes more effort to shift earlier numbers in earlier digits in a number than the later numbers, with the result that there's a preponderance of ones, or at least a higher proportion than one might expect, something like 30%. So if you have a page of financial data that you're suspicious about, if you count the digits and they defy that proportion, that's pretty good evidence that the page is made up. So where will forensic science go next, and what challenges are on the horizon? We need to recognize that everything is data now. Our news is digital. It's often based on anonymous internet videos and pictures that supposedly come from people's phones. I began by pointing out that the risk of falsehood is proportionate to what's at stake in a case. In international litigation involving states, very great issues are at stake, and the risk of fake evidence is especially high. In the International Criminal Court, there's been recognition of this risk, and they are reluctant to accept any unvouched internet pictures and video as evidence. And the same should be true now in relation to digital sound recordings, because they're also vulnerable. You may not have noticed Adobe Voco revealed to the public in November last year. You can see a content demonstration on the internet. Here's a summary of it from the BBC. A man said that he kissed...
To be impatient, that we're quite strict about 12 minutes, and
Right.
Interesting though it is, I think if you could
Wrap up. Well, I'll leave the slide for its own interest. History doesn't relate whether the lady was more upset about Jordan or the dogs. But at any rate, it illustrates the dangers of manipulation of digital evidence. We are working on this in international cases at the moment. I mention it because the techniques will no doubt appear in civil cases. Don't trust digital pictures and digital recordings.
Thank you very much indeed. The next speaker is Ben Woolgar on conspiracy theories. What next? Where next for the law on unlawful means?
Thank you very much, Lord Neuberger. This talk is about the scope of the unlawful means requirement in the tort of unlawful means conspiracy. And I want to advance two central propositions throughout this talk. The first is that the current uncertainty around this area of law and the, for want of a better term, confusion about the precise scope of the requirement makes it a very powerful tool in the arsenal for fraud litigators. And the second is that in light of a number of recent first instance and Court of Appeal decisions, the issue is ripe for reconsideration at the highest level. In previous iterations of this talk, I've been impertinent enough to make some suggestions as to how that might be done. But given Lord Neuberger's presence here, I'll leave that for him, especially because in the last few days, the Supreme Court has announced that in the middle of 2018, it will be hearing a case on this very topic in JSC, BTA Bank and Krakken, one of the cases mentioned in later slides. So, for those who are out of practice, a very brief refresher on the components of the tort of unlawful means conspiracy. There must be an agreement or combination between persons, the intended consequence of which is to injure the claimant. They must have used unlawful means to do so, and then effectively they must have caused damage to do that. It's really the third of these requirements that I'm going to be focusing on, though it will come as no surprise to learn that in many of the cases, some judges have thought that a better way of regulating the scope of the doctrine might be, for instance, to narrow the intention requirement but broaden unlawful means, and vice versa. So, what is an unlawful means? Well, until 2007, the position was relatively straightforward in the sense that the claimant had to have an independent cause of action for the thing that they alleged constituted an unlawful means. So, for instance, there must have been another tort or breach of contract, conversion, and then conspiracy was a mechanism for dragging other people who had assisted a primary wrongdoer into that tort claim. The leading case was called Powell and Bollad's, but that really did no more than confirm what everyone had understood to be the orthodox position for a very, very long time. But then, in 2008, the then House of Lords decided OBG and Alan. Now, that wasn't an unlawful means conspiracy case. It was a case about a number of other economic torts, including unlawful interference with economic interests, the tort where the classic example is the merchant who brings a claim for lost trade because the ship that was meant to be delivering or collecting his goods was being fired at by cannons. And in that case, the House of Lords was required to consider whether or not the relevant unlawful means in that tort had to be independently actionable. And it decided that it did. So it wasn't enough that somebody else had been harmed, but they had no direct claim. The third party in that situation, who you wished to trade with, had to have an independent cause of action in tort. Now, the following year, and this is where things really pick up from the conspiracy perspective, the House of Lords decided the total network case. In very brief outline, this was a carousel fraud case. The facts are set out there, but effectively there was a string of intra-community trades, some of which would have been liable for VAT. There was a missing trader, and so the revenue was out of pocket. It's a relatively straightforward, if surprisingly common form of fraud. An HMRC claimed against Total Network, which was the Spanish company, in unlawful means conspiracy, because that was effectively where the money had ended up, and it only had statutory causes of action to recover from the English companies. Now, there was an issue, I've possibly unfairly referred to it there as a side issue about a little thing called the Bill of Rights, but for our purposes, the main issue was whether or not in unlawful means conspiracy, the revenue had to have an independent cause of action against Total Network, which it accepted that it didn't. It instead relied on the common law crime of cheating the revenue to found its claim in conspiracy. So the question was, could that common law crime of cheating the revenue be unlawful means? The answer in that case was yes. But as to the broader issue of whether or not a crime could constitute unlawful means, the House of Lords said, effectively sometimes. They declined to go so far as to say that all crimes could constitute unlawful means, possibly for fairly obvious reasons, because, for instance, the sort of things that get you a parking ticket might not be sufficiently serious to ground a conspiracy claim. But that, if you like, opened up the field of the law of unlawful means conspiracy, and has led to a massive increase in the number of cases being brought and first instance and Court of Appeal decisions about what exactly constitutes an unlawful means. So, what of the recent cases? Total Network leaves certain questions about this area open. The first question it leaves open is that it doesn't tell us how we're to decide what constitutes an unlawful means. It tells us that it doesn't have to be independently actionable, but it doesn't tell us, for instance, whether or not breaches of statute might qualify, whether or not all crimes qualify. There is still an undecided issue about whether or not breach of contract qualifies, etc. The second point is that Total Network, in some respects, is a relatively straightforward case because it's a two-party case. The revenue was the obvious and effectively sole victim. Total Network was the principal wrongdoer. And one can readily understand why, intuitively, you want there to be a cause of action against somebody who has committed VAT fraud against the revenue. At least 4 of their lordships, including Lord Neuberger, said that this was a two-party case and that was part of the reasoning. But the judgment leaves open to some extent whether or not in the 3-party case you could still bring a claim. Now, what do I mean by that? Well, for instance, in the example of a company that has been asset stripped and a conspiracy case is brought by a creditor or shareholder of that company, the company itself may also have a claim against the wrongdoer for having asset stripped it. Now, there are all sorts of reasons, including jurisdiction and governing law, or indeed wrongdoer control of the company, why third parties might want to bring a claim in that situation. But there are also certain doctrinal problems that arise, which I'll come on to. Now, notwithstanding that point, it's generally been assumed in subsequent cases that, if you like, the 3-party case is no more difficult than the 2-party case. There's apparently either a builder or a woodpecker who's particularly outraged by the views I'm expressing on this subject. So, the first big case to be decided after Total Network was called Digicell and Cable and Wireless. This was slightly unusual in that it was effectively a Caribbean telecoms and competition law claim brought in the English courts. Cable and Wireless had statutory monopolies on the telecoms industries in most Caribbean countries. It had delayed allowing other people into those markets by permitting interconnection. And so it brought a claim in, amongst other things, conspiracy. Now, if you want to know where to look for the law on this area, and you can't face reading the 300-odd paragraphs in Total Network, Morgan Jay did a very effective distillation of that law in an annex to the judgment, where he considered whether or not breaches of statute, in this case the Caribbean telecom statutes, that themselves provided for no remedy on the part of private parties, could be actionable in conspiracy. So the Caribbean governments could have brought proceedings against Cable and Wireless, but had chosen not to, and there was no remedy under the statutes for Digicell. And he said, well, in those circumstances, he was unconvinced that that was sufficiently serious to constitute an unlawful means for the purposes of conspiracy. So the doctrine somewhat starts to draw back. But a number of subsequent decisions have gone in the opposite direction. In BA and Emerald Supplies, which will be known to any competition lawyers in the room as the air cargo cartel litigation, the Court of Appeal thought that breaches of foreign competition law statutes, even if those claims were time-barred and possibly not even actionable themselves, could constitute unlawful means. In Ablyazov number 12, that's the Krakenov case I mentioned earlier, it was held that contempt of court could be an unlawful means. That's the case which is off to the Supreme Court next year. In Avonwick Holdings and Castle, this was actually a permission decision of David Richards, LJ, although it's subsequently been followed by Flo J in a case called Engine and Concept Oil. He thought that breaches of Section 423 of the Insolvency Act could be the relevant unlawful means, potentially a very powerful tool if you're dealing with the sort of asset stripping case that I mentioned earlier. Now, that said, to some extent, and this is the one positive suggestion I do want to make about this area of law, those decisions dodge, and they are all, I should say, summary judgment or jurisdiction decisions, so none of these are yet trial decisions that decide the point of law finally, dodge some hard questions about this area. The first is, what do you do where somebody else might bring the claim? So, for instance, in the Section 423 case, you might be able to appoint a liquidator who would have that claim, and effectively you'd be claiming for the same loss. Now, Avonwick, in Avonwick, David Richards LJ wasn't troubled by that prospect, but there is a New Zealand decision called Wagner and Gill, which in relation to breach of directors' duties takes the opposite view and says, well, obviously you shouldn't be able to bring a claim where somebody else has also got it. And unsurprisingly, that also raises issues surrounding reflective loss. In a recent judgment called Marex Financial, Knowles J. very abruptly said that the doctrine of reflective loss didn't apply to asset stripping cases dealing with the economic torts, albeit that he didn't really explain why, although it did really seem like Mr. Sevilleja was a very nasty man who had asset stripped all of his companies upon receiving a negative draft judgment. The situation abroad, Canada, in a case called Bram Enterprises, has wound in the doctrine, so has New Zealand. And so it does seem that globally there is a lot of scope for this area of law to be, if you like, dragged in and curtailed. And that's why I think this is an issue which is ripe for reconsideration at the highest level. And on that note, I'll leave it here, and hopefully by this time next year we'll all know what the answer is as a result of Krakken. Thank you very much.
Thank you very much. Now we have Joanne Box on fraud in letter of credit cases.
Thank you. I'm going to run my stopwatch so I don't get curtailed towards the end. This talk is going to address the fraud exception to payment under a letter of credit, and in particular look at representations of law. Now, fraud often arises in the context of demands under a letter of credit. Mr. Justice Kerr's comments in Harbottle and NatWest Bank, which are on the screen behind me, are cited regularly in this context. The starting point is that banks have to pay out under a letter of credit. They're described as the lifeblood of international commerce. And even when there's a dispute between the parties as to the underlying contract, for example, a performance issue, the beneficiary of a letter of credit can demand payment from the bank. The dispute has to be resolved subsequently. However, there are limited exceptions, the most important of which is the fraud exception. Where a bank has notice of fraud on the part of the presenting party, it must not pay out. Unsurprisingly, perhaps, it's therefore quite common to see allegations of fraud when dealing with the letter of credit, even if there's no allegation of fraud in the underlying dispute. And in particular, parties often attempt to dress up an allegation that the money is not in fact due as an allegation that the demand on the letter of credit was fraudulent. It's quite common for letters of credit to require beneficiaries to certify that the sum demanded is due and payable. What then often happens is that the other side argue that signing that certificate was a fraudulent misrepresentation of law because the person who signed it did not honestly believe that the sum was due and payable. Now, in the past year, there have been two cases which have addressed this. The first case in which I was instructed is PetroSaudi and Novo Banco. The background to this case is slightly complicated. It concerned a drilling contract between PetroSaudi Oil Services Venezuela Limited and PDVSA, which is the Venezuelan state-owned oil and natural gas company. And that contract was governed by Venezuelan law. However, perhaps unsurprisingly, when the parties entered into that contract, PetroSaudi was quite concerned about non-payment. And accordingly, PDVSA agreed to provide a letter of credit for $130 million. Now, crucially, that letter of credit was governed by English law. In 2014, there was a dispute between the parties. PDVSA stopped paying PetroSaudi's invoices, and French-seated arbitration proceedings were commenced. The tribunal originally injuncted PetroSaudi from making any demands under the letter of credit for the sums that it said were due to it. But in September last year, that injunction was lifted and the matter was left to the English courts. In the meantime, and this is of some importance, the tribunal had issued 2 partial awards which looked at the payment provisions under the drilling contract. And in particular, PDVSA had produced a provision of Venezuelan public law which said that state entities had to verify and approve invoices before payment. And what PDVSA said was that, given that provision, any contractual requirement to pay money before it had gone through the approval process, which in this case it hadn't, had to be struck down. Now, when the injunction was lifted, PetroSaudi immediately made a demand for $130 million based on the outstanding invoices. Under the terms of the letter of credit, PetroSaudi was required to certify that PDVSA was obligated to pay the amount demanded under the drilling contract. Now, before the bank could pay out, as usual, there was a delay of about 5 days. PDVSA applied to the English courts for an injunction on the basis that Mr. Buckland, PetroSaudi's general counsel, had acted fraudulently in signing the certificate. PDVSA argued that it was not obligated to pay PetroSaudi because of the provisions of Venezuelan public law, because it had not gone through this approval process. PetroSaudi, on the other hand, argued that the obligation to pay arose after 30 days following presentation of the invoices, even if, as a result of some provision of Venezuelan law, PDVSA was in fact precluded from paying that sum. Now, the parties appeared before His Honour Judge Waxman QC, sitting in the commercial court on a Friday. Somewhat surprisingly, rather than determining the injunction application, the judge ordered an expedited trial to start the following Wednesday, which obviously meant that the process of preparing evidence was somewhat restricted. The bank, in the meantime, was ordered not to pay out. Now, PetroSaudi put in a witness statement from Mr. Buckland, the general counsel who'd signed the certificate, concerning the matters that he'd taken into account when signing that document. He didn't, however, waive privilege over the advice that he'd received. PDVSA put in a witness statement, or rather an expert report, on Venezuelan law, explaining why it was that they had no obligation. And after a 2-day trial, the judge concluded that PDVSA's interpretation was correct, and that no sum was due and payable under the contract. He said at paragraph 88 that the interpretation put forward by PetroSaudi, which Mr. Buckland had said he honestly believed, was something of a lawyer's construct, and he didn't believe that Mr. Buckland honestly believed it. Alternatively, he said, if Mr. Buckland did not know that the certificate was false, he had at least acted recklessly. That meant that the fraud exception was made out, and the bank was injuncted from paying. Permission to appeal was refused. PetroSaudi, unsurprisingly, applied for permission to appeal that decision. At that point, PetroSaudi hadn't had any money out under this drilling contract for several years and was on the brink of insolvency. And as a consequence, an expedited appeal was ordered. And that was heard in December before Lord Justices Lewison and Christopher Clark. That appeal was successful. In particular, the legal interpretation that His Honour Judge Waxman had considered so obviously wrong as to be fraudulent was in fact held to be the correct legal interpretation. Now, there are a number of points to take from Christopher Clark's judgment. First, when you're interpreting a letter of credit, it's important to look at the commercial background. Now, in this case, unsurprisingly, it included the need for regular payment under a drilling contract. But it also included PDVSA's long-established reputation for late payment or non-payment. Secondly, he agreed with PetroSaudi that an obligation to pay had arisen, even if PDVSA was precluded from discharging that obligation. And finally, he said as a consequence, Mr. Buckland was entitled to sign the certificate and was not dishonest in doing so. Perhaps most importantly, though, are the comments at paragraph 88, which is where the Court of Appeal considered the finding of fraud. Now, Christopher Clark expressed some disquiet at this finding. He noted, whilst there's only one true construction of an instrument such as the certificate, different legal minds may obviously take different views on such a question. And he noted the difficulty in finding that what was in essence a representation of law was fraudulent. And this is quite important. Obviously, when looking at a certificate such as the one in this case, saying that a sum was due and payable, different lawyers may well take a different view. And the message that one can take from this is that it's not advisable to jump from that possible divergence of views to finding a fraud. The other recent decision to note, also in front of the Court of Appeal, is the decision in NIGCO and Banco Santander. That case was about a road building project in Trinidad. There was a Brazilian contractor, OAS, and they'd procured a number of letters of credit. A dispute arose. NIGCO said the roads weren't being built and that they were entitled to terminate and take the security monies under the letter of credit. OAS said this wasn't true, and OAS then went and got injunctions from the Brazilian courts to try and stop the bank from paying out. Again, it was an English law letter of credit, so NIGCO applied for summary judgment. Now, the Court of Appeal gave some interesting comments, which are quite important going forward, about the difference between the test for an interim injunction and for summary judgment. But importantly, for the purposes of this talk, the court again looked at the fraud issue. In that case, the Brazilian contractor had tried to say that summary judgment shouldn't be granted because it should be entitled to cross-examine the individuals who signed the certificates to see whether they turned their mind to the relevant legal questions. What the contractor wanted to do was to establish that they were either dishonest or reckless. Now, the court was not very sympathetic to this. Lord Justice Longmore, at paragraph 38, said that it bordered on the absurd to say that the only realistic inference from the fact that businessmen did not have the relevant debate about a legal question was that they could not have believed in the validity of the demands. So what can we take away from these decisions? First, it's clear that the courts are going to be very slow to find fraud in letter of credit cases where the representation in question is one of law. It's very difficult to dress up an argument that the beneficiary wasn't entitled to the demanded sum as a matter of law, as an argument that they were fraudulent in making the demand. Now, it seems to me that that's obviously the right way for the law to go in this area. It's consistent with the previous case law, dating back to Foss and Harbottle, that the exceptions to payment under a letter of credit should be narrow. And it seems to me that particularly with representations of law, where parties may well differ as to construction, the court should not readily be making a fraud finding. Second, it's clear that the English courts are willing to take quite a robust approach to issues of foreign law in the underlying contract. Again, it seems to me that this is good. It obviously increases commercial certainty and demonstrates the value of letters of credit in these sorts of disputes, particularly when entering into a contract with an entity from another country. And the third point, which is a more difficult one to consider, is that parties should think quite carefully in this sort of case about whether they want to waive privilege. Now, there are obviously difficult considerations here, especially where there's an underlying dispute, and any advice about the certificate may well trespass on that. There's also obviously the risk of a collateral waiver. However, whilst the court is not allowed to draw adverse inferences from a refusal to waive privilege, His Honour Judge Waxman did nonetheless speculate about what must have been discussed inside Petra Saudi. That's at paragraph 79 of the judgment. And it seems to me that even where an allegation of fraud is considered to be baseless, parties should, if they want to cut through these issues quickly, consider whether or not waiving privilege would be a good idea on advice received on this point. It's true that in the Petra Saudi PDVSA litigation, the courts demonstrated that they were actually able to deal with these issues very quickly. To start with an application for an injunction in September and end up with a commercial court decision within a matter of weeks, and ultimately a Court of Appeal decision within a few months, is obviously very efficient and speedy and shows that the English courts will deal with these issues practically. However, if it's important to parties to get the money out as soon as possible, and they have taken advice that supports the signature of the certificate, it is a point that should be borne in mind. Thank you very much.
Thank you very much indeed. The final talk on this session is from Alec Haydon, who's going to talk about pre-action disclosure out of the jurisdiction.
Now, disclosure is obviously an important aspect of any fraud litigation. And if it's a subject that's close to your heart, you'll be delighted to know that this is only the first of this afternoon's talk on the topic, and that after the break, the beginning of session 2, you'll hear a wider discourse by Tim Lord QC. I'm going to speak about pre-action disclosure, because getting documents in advance can provide the victim of a fraud with a clearer understanding of what has happened to it before it commences proceedings. Indeed, in some cases, it might be said that information is considered necessary before a cause of action can even be pleaded. I'm going to focus on recent cases which have considered whether there is scope for serving these kinds of applications on persons out of the jurisdiction. Now, this is an important question in the context of fraud cases, because as Mark highlighted in his introductory remarks, fraud claims triable in England are often part of an international scheme. Should have had my slide on there. Avenues for obtaining pre-action disclosure are well known, but just to recap. Disclosure under the Norwich Pharmacal Rules is a form of equitable relief applied for by issue of a claim form. If there has been, or arguably has been, some wrongdoing, but the victim remains in the dark about an important matter, he may be able to identify someone caught up in the wrongdoing who is not likely to be a defendant itself, but who has documentation or information as to the identity of the wrongdoer or a missing piece in the jigsaw. For example, who benefited from the fraud. And that may enable proceedings to be brought. Pre-action disclosure, on the other hand, is applied for under the CPR by application notice against a person who is arguably a wrongdoer itself and may well be a defendant to future proceedings, and from whom specific targeted disclosure is sought in advance. We're going to address the question of what happens when the person holding the documents is not within the jurisdiction of England and Wales. We'll begin by looking at what has been said about service of Norwich Pharmacal claim forms out of the jurisdiction. If you were to look at the various grounds for seeking permission set out in paragraph 3.1 of Practice Direction 6b, you will see that there is no obvious basis for applying for permission to serve out of the jurisdiction. We're going to come to this recent case shortly, but before doing so, I'd like to point out that before this decision, inventive advocates had persuaded judges to grant permission ex parte, i.e. unopposed, using two of the common gateways. As is well known, one of the gateways allows service out where there is a claim made against a defendant and a real issue against that defendant which it is reasonable for the court to try, but the claimant wishes to serve the claim form on another person who is a necessary or proper party to the existing claim. In Lockton Companies versus Persons Unknown and Google, the claimant wanted information from Google sufficient to identify who would become the defendants to a defamation claim triable in England. And they were identified for the purpose of issue as the persons unknown. Permission was sought to serve Google in California. Google was the only one who was able to provide the identity of the persons who'd made the offending communications. Now, the court permitted service out on the basis that Google was a necessary or proper party to the claim against those persons unknown. But this was highly artificial, as there was no existing claim to which Google could be said to be a necessary or proper party. Indeed, if Google were not required to produce the information, there would be no proceedings against the persons unknown at all. A second case preceding this one is Bacon and Automatic. There, the court permitted service out on another web service provider in America on grounds that the Norwich Pharmacal order requiring the provision of documentation could be regarded as an injunction requiring the defendant to do something within the jurisdiction, and for that there is an existing gateway. But if a Norwich Pharmacal order were properly regarded as an injunction requiring something to be done in England, then, subject to the court's discretion and provided the requirements for relief were met, it could always be served out on anyone, anywhere in the world, regardless of their connection to England. Unsurprisingly, these two decisions were subject to considerable academic criticism. And then this brings us to the case of AB Bank and Abu Dhabi Commercial Bank. It's a classic application of the Norwich Pharmacal action, but in the context of a fraud case. The defendant to the Norwich Pharmacal claim was a bank in Abu Dhabi who might have provided information about the recipient of money arguably extracted pursuant to a fraud. But this time, there was an inter partes hearing, and the issue of jurisdiction was argued fully. Mr. Justice Tier concluded that there was no jurisdictional gateway through which a claim for Norwich Pharmacal relief could pass. 3 gateways were considered. In addition to the 2 I've just mentioned, consideration was given as to whether a Norwich Pharmacal claim form was an interim remedy under Section 25 of the Civil Jurisdiction and Judgments Act. Again, a separate gateway. But Norwich Pharmacal doesn't fit into this gateway. It isn't a form of interim relief. It is final relief as between the parties. And the gateway specified is confined to applications for interim relief in support of foreign proceedings. The proceedings here were to be brought in England. Then the judge turned to the 2 gateways that had used before and considered the necessary or proper party. Gateway first, that the bank was not a necessary or proper party to the claim to be brought in fraud against the wrongdoer who might be identified by the bank. The bank itself had no liability to the claimant, and that must be right. Considering whether or not an injunction requiring something to be done within the jurisdiction would result, it was found that the order could be complied with equally well by the bank producing documents in Abu Dhabi, and therefore a Norwich Pharmacal action shouldn't be regarded as an application for an injunction for something to be done within the jurisdiction. That brings us on to applications for early disclosure against potential defendants. And those people will be likely to be party to subsequent proceedings to be brought in the English courts. I put on the slide the extract from the Senior Courts Act, formerly the Supreme Court Act 1981, which refers to the power of the court to grant pre-action disclosure, and to CPR Part 31, Rule 16, which sets out the test to be applied in determining whether to do so. Note subparagraph A, because we'll be looking at that later, and the reference to the fact that the respondent is likely to be a party to subsequent proceedings. Neither the Act nor the CPR say anything about service of such applications out of the jurisdiction. So is there a gateway? There has been a case which has considered the matter, or at least the matter has come before it. In Clermont Energy, an application was made to serve out, but the gateway wasn't identified in the judgment. The jurisdiction challenge was somehow rolled up with the hearing of the application on its merits, and since Mr. Justice Blair decided that he would not be prepared to grant pre-action disclosure anyway, the jurisdiction fell away, the issue fell away about jurisdiction, and the arguments were simply not addressed. However, the judge referred to service out and noted, "I have considerable doubts whether this is possible, but it is best determined in a case in which the issue is determinative." In a recent case, I represented the recipient of an application for pre-action disclosure who'd been served with it in the USA. The application was made in support of a potential fraud claim. Disclosure was sought of documents which it was said would show whether my client had any basis to believe statements it had made were true. I'll say no more about it, other than to explain the basis upon which permission was sought to serve out, because it's still under judicial consideration. Reliance was placed on the last paragraph, subparagraph of paragraph 3.1 of Practice Direction 6b, and I've set it out on the slide. And you see there that permission may be granted to serve out where the claim form is for a claim under an enactment which allows proceedings to be brought. And those proceedings are not covered by any of the other grounds in the 19 previous subparagraphs. The current provision refers to enactments generally, whereas the earlier version of this gateway had actually cross-referred to a list of specific acts. As the note in the White Book indicates, these, the previous list of statutes, all contained terms within them which expressly allowed certain proceedings to be brought in England, being proceedings which had a potential for engaging foreign parties. Now, we looked at Section 33(2) of the Senior Courts Act earlier. This was the act relied upon by my opponent to say, well, that act refers to the making of pre-action disclosure applications and therefore is an enactment which allows proceedings to be brought. My submission was that this is not an enactment which allows proceedings to be brought. While an application notice can be treated as a claim form for the purposes of Part 6, proceedings, as defined in the White Book, can only be started by service of a claim form, a proper claim form, under CPR Part 7 or Part 8. The definition of claim form under those parts is not as wide as it is under Part 6. But more fundamentally, this application is by definition made before proceedings are brought. Mentioned on the slide is a comment made by Lord Justice Ricks in a case addressing Section 37 of the Supreme Court Act, Senior Courts Act now. And that's the one that provides that the High Court may grant an injunction where it is just and convenient to do so. The same gateway was considered obiter, and the question arose whether that was an enactment which allowed proceedings to be brought. Lord Justice Ricks' view was that that merely provides for a remedy within proceedings whose legal basis is to be found elsewhere. We'll have to wait for the decision in ED&F Man Capital Markets and OBEX to see whether Ground 20 can be relied on as a gateway for pre-action disclosure applications to be served out of the jurisdiction. If you're acting for a victim of fraud, you might be excited by the prospect, but I and my client rather hope it will be concluded that, as with Norwich Pharmacal Relief, there is no available gateway. Thank you.
Thank you very much indeed. We now have about just under half an hour for questions and what's rather inappropriately, in light of the table in front of us, referred to as a round table discussion. So if, and it's your opportunity to express your views, ask your questions, and please feel free to do so, preferably concisely. So who would like to open the batting? Yes.
It's a question primarily for Lord Neuberger, but everyone can chip in, obviously. Do you have any thoughts on the total network case discussed by Ben Woolgar and where the law goes from here?
I think that the total network case is a legacy of the fact that judges historically don't like conspiracy. The most obvious example is lawful means conspiracy, where you can, by two people ganging up together to do something which would be perfectly lawful if one person could do it. Nonetheless, if somebody's harmed by it, they can sue. Having invented the tort, without perhaps entirely realizing they'd done so, the judges then quickly narrowed it down progressively by saying there had to be an actual intention to harm the claimant, not merely sufficient to make a profit for oneself. As I think I pointed out in total, it's a little artificial to distinguish between me wanting to make a profit by ripping you off and me wanting to harm you. The two are a little difficult to distinguish, but there we are. In the OBG case, Lord Hoffman effectively said that you, subject to one small exception, as we heard, you can't sue somebody for simply causing you damage by unlawful means unless you can show the unlawful means represent a tort or breach of contract which you could sue them on. That presented us with a problem in total, but we said because you couldn't therefore sue somebody simply because you suffered as a result of their criminal act, unless you could show their criminal act was a tort anyway, as against you, or a breach of contract as against you. But when it came to conspiracy to commit unlawful acts, we said that that restriction Lord Hoffman invented didn't apply. Lord Hoffman, I think, doesn't like the economic torts. He, in a lecture I heard, said that he thought that the tort of inducing a breach of contract was anomalous and wrong. And I think most people think it's, provided kept within limits, right. I think that the trouble with the tort of conspiracy by unlawful means conspiracy, is that, as we identified in the total case and as was discussed, what constitute unlawful means. I wondered, it was early on in my career in the House of Lords that we decided the total case, which I think it's fairly been said in the talk we had, raised more questions than it answered. But it had certain resonance of a case which was very much towards the end of my career in the Supreme Court, the Patel and Mirza case, which, where we, as it were, reversed Tinsley and Milligan to a substantial extent, and according to many legal commentators, left the law in more of a mess than it was before, unfortunately. But nonetheless, we were feeling our way towards making the law coherent. And there were echoes of that, it seemed to me, in the total case and its analysis today, in that should every conspiracy which involves an unlawful act be potentially actionable. And I wonder whether one has to look in the same way as we suggested, as I say, somewhat unpopularly, in Patel and Mirza, at the nature of the criminal act to see whether it is such that in all the circumstances ought to give rise to a claim. Such an approach is very good news for lawyers because it leaves the law in a state of some uncertainty. And I think the hope we had in Patel and Mirza, and the hope which I don't think we articulated so much in the earlier case of total, but I think was there, is that for better or for worse, as the law has done on duty of care in tort cases, it would develop on a case-by-case basis, and gradually it would become clear. Now, as I say, that has not gone down very well with most academics in Patel and Mirza, but it does seem to me that there are some areas of law where there is no perfect answer. Tinsley and Milligan, there were two alternative answers given to the illegality question. In Patel and Mirza, two different alternative arguments, alternative conclusions were given. And it may be we are looking for a non-existent perfect answer. Beverley McLaughlin, the Chief Justice of Canada, in one judgment, suggested that what one was searching for in the end was coherence in the law, making sure the criminal law and civil law were coherent with each other in this area. It sounds very good, but again, once you start to try and work out what is meant by coherence, it's quite difficult to identify. But it seems to me one comes back both on illegality and on conspiracy, that if in the end the unlawful means involves parking a car on a double yellow line, it's unlikely to get the claimant home, whereas if it involves committing a murder, it's quite likely to get the claimant home. But when you are in areas in between, it's quite difficult. So I think the law is inherently difficult. I don't feel very proud of my contributions in total or in Patel, but it may be that I shouldn't beat myself up too much in that one's searching for an ideal that probably doesn't exist. So it's a rather long and shambolic answer to a question, but I think it's the best, as I would say, about those two cases that I can do. Thank you. I don't know, others may have views on this. Apparently not. Any other questions, not necessarily on this topic?
This is a different topic. I'd like to ask Alec Haydon about the problem about gateways for Norwich pharmacal relief. It may be that my intellectual powers are diminishing, but one of the grounds for there being held to be no gateway was that under paragraph 3.1.2 of the practice direction, service was permitted of a claim for an injunction out of the jurisdiction where the defendant is ordered to do or refrain from doing an act within the jurisdiction. And that was said not to work in Alec's summary because the respondent could comply abroad. But why could the application not be for an order that the respondent provide the information within the jurisdiction, in which case, if that was what the order said, the respondent could not comply with it by doing it abroad.
Exactly, and that is how you might try to reconcile that case with the Bacon and Automatic decision. It's not clear from the reference in the Bacon and Automatic case, quite what the order required, and it may have been worded precisely as you suggest. In the AB Bank case, though, the order had been drafted more broadly, simply requiring provision of the documents to the applicant. And on that basis, Mr. Justice Tier was able to say, well, this particular order didn't require to be performed in England and Wales. But just stepping back from it a little bit, if any order required something to be done in England, for example, a witness to arrive in England to give evidence, or someone, as in this case, to produce documents or information, it's not really in the spirit of the rule, which permits service out on this basis, to allow it to be used for these kind of orders, because it would allow the court to expand its own jurisdiction simply by requiring attendance or production in England. What the ground has in mind is other acts which can only take place in England, and to stop doing something in London, or to not do something within a particular region, in my view. But that is clearly an area which can still be explored.
I have a question on Joanne Box's talk. I'm Charles Williams at Thomas Cooper. I was on the losing side of the Banco Santander case, and I commend Joanne Box for being more philosophical about the Petro-Saudi case than I am about the Banco Santander case. Now, in both cases, the basis, and this has been commented on by a number of commentators, that it is all about autonomy and a great victory for autonomy. This rather bemuses me, because I've always understood that the basis for autonomy was that a bank could only work on the wording of the letter of credit, and that the doctrines of strict compliance and autonomy both stem from the fact that the bank's protection is in that wording. Yet we see, and you put up a slide stating one is looking at the contractual background, and certainly in Santander, Longmore LJ referred the interpretation, or slightly obliquely, of the standby to the underlying contract. Now, I find a contradiction here as between a liberal view of the wording and as to the doctrine of autonomy as traditionally understood. And I think one can say that this just goes to the mindset of the beneficiary, in that how he understood the contract. But my understanding of the judgments was that they went a little further than that.
I think that's an excellent point. I think in both of those cases, you see the courts being willing to look at the background, which does cause difficulty for a bank. Ultimately, as far as the bank's concerned, when they see the documents, if they look compliant, they're entitled to pay out, unless a matter is brought to their attention that there may be an allegation of fraud. I suppose the difficulty that arises is that if you're then required to see the whole contractual background in order to assess whether that allegation of fraud is a good one, that may well be information that the bank doesn't have. In some ways, you can say the bank is in a safe position, because providing it acts reasonably on the basis of what it's seen, it won't get into difficulty. And it may be that those sorts of questions of background and interpretation will only ever come to the fore when you're actually already before the courts, usually because the applicant for the letter of credit has tried to bring an injunction. But it is difficult to say how far the court should go. But you can see the appeal of looking at the big picture and sort of in particular, what prompted the use of a letter of credit in the first place when trying to decide whether or not a particular certification is fraudulent. Obviously, acting for Petrosaudi, we were very keen on autonomy of letter of credit, very keen to say, you know, absolutely, the fraud exception should be narrow. But I think that having such a narrow exception probably is in keeping with not only the case law to date, but also the expectation of parties. I think usually when someone enters into a letter of credit, it's because they're concerned that the other party might not pay. And that particularly if the underlying contract has a foreign law where they're not particularly comfortable with those courts. And I think that the real value in an English law governed letter of credit is that you can expect the exceptions to be very narrow. But that's not an appealing conclusion if you're on the other side faced with one of these cases.
I was quite interested in the comments on witnesses. When I became a judge, I thought that the difficult part would be deciding points of law, and the factual aspects would be easy. And I discovered that the factual aspects weren't easy. In complex factual litigation, you rapidly come to the conclusion that most witnesses are not completely truthful. But one of the complicating features is that in the majority of cases, perhaps I'm naive, the untruthful witnesses are not actually telling lies. Certainly by the time they come to give evidence, they're believing what they're saying, which is one of the reasons why, not the only reason, but one of the main reasons why I'm very uncomfortable about, and always have been, about deciding cases on how the witnesses fared in the witness box. And I think that's particularly true of expert witnesses that we were hearing about, who often, in their expertise, are very committed to their views, either because they are passionate rather than dispassionate scientists, or because they've spent a lot of time with the legal team who they're supporting and have become, as is almost inevitable, human nature being what it is, converted to their views. I think another problem a judge faces with expert evidence when it's of a technical nature is that you often don't have what Lord Gough decided in that passage that was quoted in the talk had mentioned, which is to be able to fall back on commercial common sense, on the inherent likelihood, on what looks more consistent with contemporaneous documents, a sort of fallback which is so useful. With expert evidence of a technical nature, you have none of that unless you happen to be a technically qualified or experienced judge in that particular field. In that connection, in some patent cases, the two experts get together to produce a primer for the judge, to at least give the judge the technical background. The Royal Society and the judiciary are now getting together with a view to producing primers on the sort of issues which judges frequently come up against, with a view to at least saying this is what is the established scientific technological view, and you can take this as read. Because one of the worries always is that one side has gone to a scientist who is way out, but the judge may not be able to assess whether that's true. The bar has done something on this too. The Inns of Court College of Advocacy has got together with the Royal Statistical Society to produce a 60-page booklet on statistics, which, particularly in criminal cases, notoriously, judges and barristers and solicitors have made something of a mess of. And I'm sure it has happened in civil cases too. Another thing that strikes me, particularly listening to the very interesting up-to-date stuff that Michael Swainston described, is that, of course, with every little piece of new detective work, you give a new weapon once it's publicized to the villains. No doubt now Benham's law is no use at all, because anyone preparing a list of figures will ensure that one occurs 30% of the time. And you will then get refined expert evidence saying that the fact that it appears 30% of the time on 8 consecutive pages is in fact evidence of fraud. These things get quite subtle. But expert evidence has always provided problems for the courts. And maybe with AI and so on developing, we will have new techniques of helping us in disentangling expert evidence.
Do you think it would be helpful to sit with an assessor in expert cases so that one isn't so reliant on the two sides, hired hands who, as you say, are very often party pre?
I think that's a very interesting idea. The advantage of the primer rather than the single expert is that, who you're sitting with, is that you have a consensus view, and the risk always is with one expert that however much he or she appears to be an independent expert, he or she will have a particular point of view. I've sat on a couple of patent cases with an expert, and the trouble is either you almost hand over the deciding of the case or the expert issues to the expert, and you simply adopt what he or she says, or they are so anxious not to involve themselves in deciding the case and keeping your judicial role intact, that they provide very limited assistance. And I think the idea of a primer, which is more of a consensus document, is more useful. But of course, you can say perfectly rightly that particularly in the sort of areas we're discussing, the nature of the expert evidence will be such that it's not the sort of thing which is so common that there'll be a primer about. So I think an expert might be useful, but my experience personally of them, which is limited, is that they are of limited use.
Since no one else has asked a question, I'm going to ask a second one, I'm sorry. But it comes back to your point about witnesses being inherently unreliable through no fault of their own. Just memories fade, memories change. Which takes you back to, okay, we'll look at the documents, we'll look at the contemporaneous documents, which takes you straight into widely perceived one of the biggest problems with commercial litigation, which is the volume of disclosure. How are we going to square that circle? If we're going to rely on documents, not the witnesses, we're going to be stuck with vast documentary, expensive, time-consuming documentary exercises.
We may be. First of all, when I started as a judge, we were in a worse place, I think, than we are now, because we were at a stage where, this was 96, electronic material was rapidly replacing paper material. Everything was recorded. So we had the mass of electronic material, the recovery of stuff that had been deleted and so on. But we didn't have the search tools which have now been developed. Now, whether those search tools can be improved, whether with AI and so on we can get more and more refined investigation of electronic material, I'm not competent to say. But whether anyone's tried in the common law field the civilian approach of letting each party produce the documents they want and leaving it at that, I don't know. But the advantage of that is that it limits the amount of documents very considerably. The disadvantage, of course, is that you don't get the documents that harm your opponent, which only your opponent has. And the question is, which is a difficult one to assess, is the game worth the candle? Is it worth saying we will play the civilian game and take the risk of not finding documents which might decide the case, ensure the case is decided rightly and differently, because we're not making each side give disclosure? There's no perfect answer to this. I think one of the trouble with the common law system used to be that we used to think that somehow if we had the full Monty with full disclosure, full cross-examination, that we would get to the truth. And I think sometimes you're in a wood and tree situation where actually you're less likely to get to the truth. But it's certainly true that the more you cut down the material you can decide on, subject to the wood and trees problem, the more of a risk there is of injustice. But maybe it's a question of balancing it out and saying we've got to depart from full disclosure. There was a sort of half-hearted departure under the Wolf reforms. You will know much better than I do, because I went to the Court of Appeal sort of while the Wolf reforms were working their way through on this. But I don't get the impression that it has made a great deal of difference in commercial litigation, and I always took the view in substantial commercial litigation that the sort of things that the Wolf reform were aimed at were not really for big commercial litigation where the parties should be able to look after themselves. In a sense, I'm the least capable person, the least appropriate person to be answering the question, he said, having answered it, because I've been doing appeal stuff for 10 years or more. Somebody else want to say
something? Hugo Plowman from Mishcons. Slightly left field question, but also slightly connected. We've heard the City of London talking about setting up a new court to hear cyber and fraud cases, both criminal and civil fraud cases. And I just wondered if anyone had the inside scoop on the panel as to exactly what that means.
Now, I'm afraid you've scored a go. Nobody has an answer. I think you might get some flannel from some of us, but it won't really be very informed. So I'm afraid there isn't an answer to that question. Right, well, I think it's tea time. So thank you very much indeed. I think we should show our appreciation to the four speakers.